I will call the House Judiciary Finance and Civil Law Committee to order. Thank you for being here on this very, very cold day in Minnesota. The first thing we will want to do is have approval of the minutes from January 16th. All right, Representative Hudson.
Thank you, Madam Chair. I move to accept the minutes from the previous meeting.
Thank you. There's a motion to approve the minutes. Any discussion? If not, all those in favor, please say aye. Aye. Opposed, same sign. Minutes are adopted. This morning, we are very honored to have with us representatives from the courts and from the Board of Public Defense. And so thank you for being here, Mr. Shorba. You made it all the way over from the court building via tunnel, I'm sure. And what my plan here is, folks, is we'll let them give their entire presentation, and then we'll take member questions after that. So, Mr. Shorba, thank you for being here. Please introduce yourself and go ahead with your testimony.
Good morning, Chair Scott, Vice Chair Hudson, and members of the Judiciary Finance and Civil Law Committee. My name is Jeff Shorba, and I have the distinct honor of serving as Minnesota's State Court Administrator for the Judicial Branch. And I'm really pleased to be with you today. We are willing to come anywhere and tell our story, and so we really appreciate the invitation from the chair to come here. And also, hopefully, seek your support for the 26-27 fiscal year budget. So, just a little bit of an overview. The Judicial Branch's mission is to provide justice through a system that assures equal access for the fair and timely resolution of cases and controversies. That mission is enshrined in Article 1, Section 8 of the Minnesota Constitution, which promises that every person is entitled to access justice freely, promptly, and without delay. And upholding this promise is the most fundamental obligation of our state's court system. The Minnesota Judicial Branch comprises 3 levels of courts: Supreme Court, Court of Appeals, and 87 district courts across the state. We currently have a total of 322 judges and roughly 2,800 court staff processing the 1 million cases that are filed in our district courts each year. Those judges and staff work in 103 court locations, actually more than any other part of state government. Our current fiscal year 25 budget is approximately $479 million, which is approximately 1% of the state's budget. And we believe that is a modest investment in a court system that is viewed as among the most innovative and well-managed in the entire country. Our district courts, our trial courts, are organized into districts. There are 10 judicial districts in the state, which you can see on this map. The boundaries are set by statute. We have 2 one-county districts, 2nd Judicial District in Ramsey and the 4th Judicial District in Hennepin. The rest range between 7 counties and 17 counties. In fact, our largest district in terms of area, the 9th District in Northwest Minnesota, is larger than 10 states. So it's quite the geography to cover. This organization into districts serves 2 important purposes. First is for elections. Our district court judges are elected by judicial district and are authorized to hear cases anywhere within the district. And the second is for administrative purposes. Each district has a chief judge, district administrator, who share responsibility for managing the district. Turning now to our administrative structure, the Chief Justice, currently Natalie Hudson, is the administrative head of the system and responsible for the overall management of the entire judicial branch. She serves as chair of the Minnesota Judicial Council, which is the single administrative policy-making body for the judicial branch. Each of our 10 districts and both of our appellate courts have representation on that body. I serve, along with my employees, as staff to the Judicial Council. We provide central administrative infrastructure services to the entire judicial branch, including human resources, finance, legal, research, information technology, and statewide program management. The Chief Justice, of course, leads the Supreme Court, which continues to have the responsibility for regulating the practice of law, including the promulgation of statewide rules of procedure and practice for all courts of the state. There is a Chief Judge of the Court of Appeals appointed by the governor who serves as the head of that court. And there's also a Chief Judge in each district elected by the branch who is responsible for management of the entire district. The Chief Judge is assisted, as I mentioned, by a Judicial District Administrator, and then there are county court administrators doing operation work in each of the counties. As part of our efforts to ensure fair and timely access to justice and uphold the constitutional rights of Minnesotans, our courts have the responsibility to deliver and pay for many different types of services pursuant to Minnesota statute. Under Minnesota Statute 480.182, the branch is required to pay for several court-related costs, including guardian ad litem services, court interpreters, mental health examinations in criminal and civil commitment cases, and jury program expenses. Our courts are seeing significant increases in the needs for many of these services, and you'll hear me talk about the rising cost of delivering these services later in my presentation. Here again is a reminder that the Judicial Branch, the third branch of government that protects the constitutional rights of Minnesotans and processes those million cases, represents just a tiny fraction of our state's general fund budget. Our courts are funded almost entirely through legislative appropriation. All of the revenue we collect through court fines and fees is deposited in the state's general fund or to local government or other statutorily mandated programs. We do not retain any of that revenue. We depend on your appropriation to fund the vital work of the judiciary. On behalf of the branch, I would like to thank you for the significant investment in the state's justice system in 2023 and 2024. We generously received approximately $86 million in ongoing funding and approximately $52 million in one-time funding. Through this funding, we are able to make our compensation structure more competitive with our public sector peers, helping to ensure our courts have the qualified judges and staff needed to maintain timely and effective access to justice. We eliminated the pandemic backlog of felony and gross misdemeanor cases. While many other states are still wrestling with backlogs and delays stemming from the pandemic, we are proud to say that we've reduced our pending caseloads to pre-pandemic levels. We enhanced courtroom technology to expand access to justice through the use of remote and hybrid court hearings. We temporarily addressed budget deficits in critical court programs such as psychological services, court interpreter, jury, and cybersecurity. We sustained 4 recently launched treatment courts to expand access to these vital and very successful court programs. We also raised the payment rates for court interpreters and provided a modest pay increase for psychological examiners to help us keep pace with the payment rates of our public sector peers. These investments and their impacts highlight the power of partnership between the legislature and the judiciary. However, ongoing challenges and demands require sustained investment to ensure courts remain accessible, secure, and effective. In addition to the progress we made through legislative appropriations, I'm proud to report that this was another year of important and historic accomplishments for our state's courts. Earlier this year, the Minnesota Council adopted a new district court hearing framework that will determine how our courts use both in-person and remote court hearings to deliver justice to the people of Minnesota from now into the future. This new framework reflects all of the lessons and experiences we gained leveraging remote hearing technology during the pandemic and is the culmination of 3 years of work to listen to court users and make our courts more accessible and effective. That historic new framework will officially take effect on February 3rd. In addition, over the past few years, we have launched several technology enhancements to improve the court experience, such as the Minnesota Digital Exhibit System, a new e-check-in system for court hearings, and an online scheduling tool for DOC incarcerated individuals. The Judicial Branch has strengthened its collaboration with justice partners to address these justice-related issues. The Minnesota Judicial Council created a new mental health justice initiative to foster collaboration between the branch, justice partners, and community members to improve outcomes for individuals who are living with mental illness. We are also meeting regularly with court interpreters and psychological examiners through newly established work groups to explore options for improving the delivery of these critical services. I'd now like to turn your attention to the Judicial Branch's 26-27 budget request. We recognize that this session begins with a challenging budget forecast, requiring you to make very difficult decisions about how to allocate limited resources. The branch remains committed to being an exemplary steward of public funds, and we approach the process of submitting our biennial budget request with the utmost care and responsibility. At the same time, as a co-equal branch of government, we have a duty to our employees, judges, and the people of Minnesota to secure the funding necessary to fulfill our constitutional obligation. Justice delayed is justice denied. Given the modest share of the state budget allocated to the judiciary, we respectfully urge our partners in the executive and legislative branches to prioritize the essential role of the courts. This budget request is focused on helping our courts address some of the key challenges facing our judiciary at this moment. As I go through these next slides, I'll highlight some of the key challenges and talk about how our budget request aims to address those issues. The judiciary's ability to deliver timely and effective justice depends on its people. Judges and staff are the foundation of our court system, ensuring that it operates smoothly and effectively. However, the judicial branch is facing significant recruitment and retention challenges that jeopardize its ability to sustain operations. The first key challenge is a compensation gap. A recent market study revealed that salaries for judges and staff lag significantly behind those offered by other public sector employers in Minnesota. This disparity creates a competitive disadvantage, making it increasingly difficult to attract and retain talent. The second challenge is increasing turnover. Since 2020, the Judicial Branch's employee turnover rate has risen by 15%, while the number of applicants for each open position has fallen by 27%. The leading reason employees cite for leaving is inadequate compensation. So to address these challenges, the branch is requesting $77.3 million in 26-27 and $104 million in 28-29 to increase judicial salaries by what our market study told us we need to do, which is 6%. Fund the employer's share of anticipated healthcare cost increases. We just follow the state insurance plan, and you know those costs always go up. And cover the increased cost of leasing office space. We have a building across the street, the Judicial Center, and our landlord is the same as yours, the Department of Administration, and we are told that costs are going to go up for all of us. So this investment is really, really critical. The next part of our request relates to digital accessibility. Justice must be accessible to all, including Minnesotans with disabilities. And the Minnesota Judicial Branch has had a long-standing commitment to providing accommodations that ensure access to our courts. In recent years, we have also taken proactive steps to enhance the digital accessibility of our online resources. Then in April of last year, the Department of Justice at the federal level issued a rule amending the American with Disabilities Act to establish specific digital accessibility requirements for state and local governments. These requirements must be met by April 24th, 2026. To achieve compliance with these new federal guidelines, we have launched a significant project to review and ensure that all of our online resources and content are digitally accessible and meet these new federal standards. It's a major undertaking requiring the remediation of over 1 million web and case-related documents, revisions to more than 1,800 web and Minnesota Court Information System templates, and updates to approximately 22 information technology applications. So to support this effort, the branch is requesting $5.1 million in fiscal year 26-27 and $1.76 million in 28 and 29. And this one-time funding will be used to remediate our existing online resources and provide training on digital accessibility best practices throughout the judicial branch. The smaller ongoing funding will be used to ensure our ongoing compliance with these new ADA requirements and to maintain existing software and licensing costs. This is an extremely important effort, not only for ensuring our compliance with federal guidelines, but also to ensure fair and timely access to court information and resources. I next want to talk about our efforts to improve how we share court records and information with our justice partners. Since 2003, the branch has provided electronic access to court documents and other case records for statewide justice partner agencies through a small number of discrete legacy applications. Over the past 2 years, vendor support for several of these aging applications was discontinued due to cybersecurity and ongoing maintenance concerns. In response, we formed a statewide work group of justice partners to discuss best practices and provide feedback on accessing court records and information using branch-provided tools. Through the Justice Partner Access User Group, the branch held a series of 19 feedback sessions, which involved more than 100 individuals representing justice partner agencies, advocacy groups, and private attorneys. Through those sessions, the group identified many ways to improve how our courts share records and data. So this session, we are requesting $4 million in 26 and 27 and $800,000 in 28 and 29 to implement the Justice Partner Access User Group's recommendations and develop a modern access system with improved functionality, reliability, and security. This one-time funding would be used to develop and implement the new Justice Partner Access application. The ongoing funding would be used to maintain, again, the hardware and software licensing and deliver training and education on the new tool to end users. This request is really an important investment in strengthening our collaboration with justice partners and ensuring the efficient and secure sharing of court records and information. By implementing these recommendations, we can modernize our systems to meet current needs, improve functionality, and ensure security. The next part of our budget request is focused on ensuring we can find qualified examiners to meet the growing need for psychological evaluations in our court system. The need for forensic medical evaluations in criminal and civil commitment cases has really surged in recent years, with a 143% increase between fiscal year 2020 and fiscal year 2023. This sharp rise has put significant pressure on the branch's capacity to meet this critical need, not only to pay for the rising costs of delivering these services, but in being able to find an adequate number of qualified examiners to conduct these evaluations in a timely manner. We are deeply appreciative of the legislature's action last session to raise the pay rate for forensic examiners from $125 to $136 per hour, the first increase we have seen since 2009. However, despite this progress, the branch continues to face a shortage of qualified examiners on its roster. This shortage creates delays in conducting evaluations and hinders the timely administration of justice and potentially civil liberties. So over the past summer, we conducted a comprehensive review of examiner pay rates across various markets and areas of practice. Based on that analysis, we believe we need to increase our pay rates for contract examiners to $175 per hour to remain competitive with the broader market and ensure we can find examiners to conduct these evaluations. So we are seeking $7.2 million in FY 26-27 to increase the hourly pay rate from $136 to $175 to align with market rates and make sure the judiciary is still competitive. The next section of our budget request relates to the compensation we provide to Minnesotans called to jury service. Jurors are the cornerstone of our justice system, and a representative jury pool is essential to maintaining public trust and confidence in the courts. However, the current $20 per day juror per diem fails to account for the financial burdens jurors often face, including transportation costs, parking, meals, childcare, and lost income from missed work. This low compensation creates barriers for many individuals, particularly those with lower incomes, small business owners, farmers. These barriers can reduce participation and really affect the representation in jury pools. Feedback from potential jurors frequently highlights the inadequacy of the current per diem as a significant obstacle to serving. So to address these challenges, the branch is requesting $18 million in 26-27 to increase the juror per diem from $20 per day to $100 per day. This increase was figured based not only on looking at what other states are doing, but also looking at what me as a hairdresser, me as a farmer, me as a independent business person would need to have in order just to meet the minimum wage. So times 8 hours gets you to about $100 when you look at the minimum wage that we have here in the state. We believe that we should be as good as North Dakota. They just raised their rate to $100 per day. I don't say that disparagingly, but I do think that we can be competitive. So we also want to raise the mileage rate to be in line with the federal rates. Mandated services funding. So I talked a little bit about this before. The judiciary is statutorily required to provide interpreters, psychological exams, jury services to ensure access to justice and uphold constitutional obligations. However, rising demand has created a significant deficit in these areas. As I mentioned, the need for psychological exams has increased 143%. The number of interpreter events in our district courts have nearly doubled since 2019, covering right now 134 different languages in Minnesota. And at the same time, we've seen printing, postage, and other costs place strain on our jury program budget. So last year, the legislature provided temporary funding to address these deficits through 27, and we're grateful for that support. However, the costs continue to rise. They're not going down. And so we would seek permanent funding in the 28 and 29 biennium to provide long-term solutions. Finally, we all know how important the issue of cybersecurity is, critical to ensuring the confidentiality, integrity, and availability of the sensitive data entrusted to the judicial branch. Our cybersecurity program is designed to protect this information through a carefully coordinated suite of technology, processes, procedures to ensure that the public, private, and sealed data remain secure and reliable. As cybercrime becomes increasingly organized and cyber criminals continually adapt their methods, the branch must evolve its defenses to stay ahead of these threats. The need has never been greater in the cybersecurity area. We are deeply grateful again for the one-time funding the legislature provided last session for our cybersecurity program. However, this funding again is set to expire in '27, leaving a critical gap in our ability to sustain essential protections. We want to stay ahead of the cyber criminals, but we need to invest in order to do that. So here you have this request on this slide. You can see a summary of the overall biennial budget request. In total, our budget request represents a 12% increase over the fiscal year 26-27 starting biennial base budget. And we have carefully debated options, alternatives, ideas to get to this request. So let me conclude by just reminding you again, the judicial branch is not just another government agency. We're a co-equal branch of government and a cornerstone of our democracy. I think I don't need to remind you all the things that are going on in our courts right now, and so we need support. And we really take great pride in all of the progress that we've been able to achieve together and our continued partnership with the legislature. And we think we can even further strengthen our judiciary and build a more equitable, effective, and resilient system for future generations. So thank you for your leadership. Thank you for the invitation and your commitment to the people of Minnesota. And I'm certainly available today and any other day to come and answer your questions.
Thank you, Mr. Shorba. And is Ms. Lehman, is she presenting today as well? No. Oh, man, I was going to call her up to the table.
Well, you can call her up. She may have something to say.
She can be your phone a friend.
There you go. I may need her, so we'll
Yeah.
see.
Thank you, Mr. Shorba, for your presentation. And we have a couple of member questions. And first on the list is Representative Rarick.
Thank you, Madam Chair. I actually have 4 questions. Can I just fire away?
Go ahead.
You know me. Thank you, Madam Chair. So as you were going through your presentation, 4 questions came up. So the treatment courts, so you have 4 newly launched treatment courts. Can you let me know about what is the amount that you're providing for them each year?
Mr. Shorba.
Madam Chair, Representative Rarick, I don't have that number off the top of my head. The way the treatment courts work, and you're familiar because you've been here before, we usually start them off with federal funding. And so we have some that are currently federally funded, they have grants. And then once those grants, usually 3 years, are over, then we come to you and ask you to provide the state funding that we need to keep them going. But I'm certainly able to break that down for you and give you more information on treatment courts. As you're aware, treatment courts have been one of the most studied part of government. And all the studies show that they are successful, especially in getting people who've not been successful through other means to lead a more stable and drug-free life. So we're very proud of them.
Representative Rarick.
Thank you, Madam Chair. I agree wholeheartedly. I was the one that expanded them across the entire state to make sure every jurisdiction, every court could have one, at least one type. There's multiple types of treatment courts. And of course, before I was willing to do that, I think I went to 10 or so different types and different locations of treatment courts before I was willing to do that. So I'm well aware. I actually still serve on the advisory board for Wright County's treatment court. So, and that's really where the question comes from, because I get to sit, with them and hear their challenges. So if you could get back to me as to how much you're funding each of the new treatment courts and then how much you're funding the existing.
Yep.
I understand that some of it is federal and there's a transition time, but that would really help me.
Yep.
Because at least anecdotally, from the treatment court that I'm well aware of in Wright County, there may be a gap there. And so I just want to make sure that they are fully funded because they have been incredibly successful. My next question is, you talked about the cost of employees. And I've been on the subcommittee on employee relations for a decade or so and have chaired it in the past. Do you negotiate with the unions for the judicial branch, or does the executive branch negotiate for those employee unions?
Mr. Shorba.
Madam Chair, Representative Rarick, we do all of our own negotiations. We have our own compensation structure. We currently have 3 unions. We're represented court reporters are represented by Teamsters. We have 9 of our districts that are represented. 1 district has no union employees. And we have to negotiate with ASME in a number of districts, and then the Teamsters again in 2 districts. Very complicated. We have a whole bunch of unrepresented employees. All the people who work across the street here are not part of a union. So our compensation time is very busy, and I have my HR director here who looks very tired from going through all this. But so we do our own. We do not go through the executive branch.
Representative Rarick.
Thank you. Thank you. I'm glad to hear that. You should have the power over your own employees, including the negotiations with the union. So I'm glad to hear that. I'm not sure why I didn't know that after 10 years being on the SCR, so I appreciate you saying that. Next question is what is the availability of mental health counselors? And I'm really interested in the return to competency. So if you need to return someone to competency, is there easy access and availability of counselors and therapists to send them to, or is that a lack?
Mr. Shorba.
Madam Chair, Representative Rarick, I'm going to delve into this area. That's one of the reasons why we established this mental health advisory group. And we're bringing people not only from the judicial branch, but providers, attorneys, the bar, public defenders together to talk about the issue. We're sort of at the front end of the issue in terms of doing the exams. We're not involved in the mental health support part of it. Of course, they would come back to the court to see if they're competent to stand trial. So the issue that we're dealing with in our budget is really trying to get someone to first say whether they are competent and whether they can go to trial. And that's where we're having the problem. I would not disagree with you that there is a shortage. I was just at a meeting in Olmsted County with a whole bunch of people to talk about mental health needs. And unfortunately, some of the most severely mentally ill are sitting in jails waiting to have either exams or to have a treatment bed, because there are very few treatment beds. They're very expensive and they're scarce. So it's a big issue. We're hoping to collaborate together with this group, and I don't know what solutions we'll come up with, but it is a very, very big problem.
And Representative Rarick, my understanding from staff here is that next Tuesday, we're going to be hearing from that competency board. So save your questions for that, too. Do you have another question?
Yes, Madam
Representative
Chair. Thank you. So my last question is very short. Just, you had talked about forensic examiners, and what is the qualification? So the degree or licensure that needs to be attained for that position?
Mr. Shorba.
Madam Chair, Representative Rarick, it's set by statute, and usually the individuals have to be either a psychiatrist or a psychologist and licensed. We have, during the pandemic, tried to expand our pool a little bit by getting even individuals who can do these exams remotely from other states, because people are retiring and they're just not getting into this field. And if they are, they're probably going to DHS, which pays more than we do. So we are very, very stretched. But if you've ever not only sat in on an exam, but also looked at the reports, these are very voluminous reports that they do to try to determine competency and other kinds of things. Because if you are institutionalized for some reason because you are mentally ill, that is taking away your civil liberties. So it's a really important job, and we're very grateful for the ones we have. We just don't have enough. Thanks for the question.
Representative Rick?
Thank you, Madam Chair. So yes, that's a very high level. It's one of the highest level degrees and licensures. So PhD level, I could see why that would be difficult to obtain. We don't have a lot of those throughout the entire United States. So thank you. Thank you, Madam Chair.
Thank you. Good questions. Representative Engen?
Thank you, Madam Chair, and thank you, Mr. Shorbel, for this. I saw that you guys made it through that pandemic backlog. Having worked in Hennepin County in the courts during kind of the height of the pandemic, I saw that a lot of those virtual hearings was actually attributing to that backlog. People were missing the mail that had the Zoom link in it, or it was being sent to an address that they no longer stayed at. And it seems to me like you guys are kind of maintaining that virtual aspect of court and expanding that to some extent. And I'm sure that comes with a lot of pros, there's a lot of ease that comes with that, but what are some of the challenges that you guys see with this? I'm not sure that it's always appropriate, and it definitely comes with its own issues, so I want to hear a little bit about what you guys think about that.
Mr. Shorba?
Madam Chair, Representative Engen, that's a very important question, and that's why we've spent 3 years studying this. If you had asked me on day one of the pandemic how to operate court remotely, I would have told you we're making it up as we go along because we weren't able to plan. We didn't know a pandemic was coming. Now, years later, I think we've got it much better under control. We've instituted technology in our courtrooms to allow us to better access individuals. We have trained staff to take over some of these Zoom hearings in a way that they didn't know on day one of the pandemic. Our judges took a lot of time and effort to try to get them to understand how to make the courtroom of a Zoom link something that was like the courtroom in person. And we agree with you. This is not for every kind of hearing. If you have a jury trial, if you have an evidentiary hearing, you're coming to the courthouse. But for situations, and I know the public defenders are going to be talking to you next, but for situations where we may have a 15-minute hearing or a whole day of 15-minute hearings, attorneys, and we've heard this from the public defenders and others, are able to get to more of these and represent individuals. And mostly we heard from people who just don't go to court very often. And in order to go downtown Minneapolis, pay for parking, take time out, childcare, all kinds of things. They would rather just take a break from their job for 15 minutes and be present. So we have set out a very distinct framework for when we think it's appropriate, when we don't think it's appropriate, and we're going to study it February 3rd till the end of the year, and we may change. We may change things.
Representative Engen, follow up.
Thank you, Madam Chair, and thank you for that. Definitely agree with you. I'd be curious to see what the numbers shake out to be when it comes to percentage of increase or decreases in failures to appear, for example. Is that something that you guys can provide to the committee?
Mr. Shorba?
Madam Chair, Representative Engen, absolutely. And we have already seen that failures to appear have gone down.
Terrific. Awesome.
Representative Engen?
Thank you, Madam Chair. Second question here, cybersecurity challenges. Could you give me some details or some insight as to what it is that you guys are currently dealing with in this ever-changing criminal act?
Mr. Shorba?
Madam Chair, Representative Engen, I'll be a little bit circumspect because obviously this is a public hearing, and I'm happy to come with my IT director and talk to you in person. We are seeing the same kind of attacks that others have seen. Fortunately, we have done a lot of work. We did have an attack probably 6 years ago that took down some things for a short period of time, but we were able to bring it back up, and we were able to staff up our cybersecurity team. I'll talk, maybe just give you an example of another state, Kansas. Kansas had a cybersecurity attack, and they had to go back to paper. And they were down for well over a month. Knock on wood, we haven't had that happen here, but we don't want to get behind. And so we actually sent some of our team down to Kansas to help them out because we are sort of becoming a leader in the cybersecurity area. So I'm happy to come and give you a few more details in person.
Representative Engen?
That's terrific to hear. Great job, you guys. Would definitely take you up on that offer. But third and final question, if I may, Madam Chair.
Representative Engen?
Thank you. Psychological and interpreter percentage increases. I mean, that seems pretty staggering if we're talking about twice the need for this. I know we're kind of saying it's one time because we're seeing this dramatic spike, but are you guys, first off, why are you seeing these increases? And second, do you assume that they're going to be long-term trends now?
Mr.
Madam Chair, Representative Engen, we believe there are long-term trends. We are having more individuals who speak foreign languages living now in Minnesota. That's why those interpreter events are going up. And those are not only foreign languages, but sign language as well that we need to provide constitutionally and statutorily. And we're seeing more mentally ill people coming into the court system because they're getting into trouble on the street, whether that's due to homelessness or due to alcohol abuse or drug abuse or not having a place to go, and then they do something that brings them into the court system. So we had a very interesting conversation in Rochester with our police officer colleagues who are dealing with this issue daily, and it's really become an epidemic. So I do not think these costs are dramatically going to go down unless we have figured out some solution, and we're not going to teach everyone English, so we're probably still going to have these interpreter events, and I don't know when we'll solve the mental health crisis.
Representative Engen?
Well, thank you for that. I think you're 100% spot on, and it also requires us to sit around a round table with the stakeholders, the police groups, our counties, talking about the jail capacity, and yourself, to try to figure out a way that we could actually make this a sustainable and workable initiative going forward. So I appreciate the insight.
Any other member questions? Representative Hudson?
Thank you, Madam Chair. Mr. Shorba, so kind of going off of what Representative Engen had to say regarding these dramatic increases in mandated services and hearing your exchange just now that you described it as epidemic and not going down, I'd be interested, and I don't expect you to have this information available here because it's a novel request, but it's one thing to see the numbers presented as they are on this slide. It'd be another thing to look at like trends year over year. I'd be interested in trying to sift out some sort of correlation between what's being done in public policy and this sudden spike in the need for services that doesn't appear to be going down anytime soon. Thank you.
Mr. Shorba?
Madam Chair, Representative Hudson, we are all about data in the Judicial Branch, so we have more data on everything than I can shake a stick at. So we are happy to provide you with some trends. We're also happy to have any of you get an invitation to come and watch this mental health advisory group meet. All of our meetings are public, but I think the idea of more roundtable discussions is very, very healthy, and we are happy to bring data to the table. My research staff will love it if they get to present some data. So thank you for that question.
Any other member questions? Mr. Shorba, thank you for being here. And I want to just congratulate the courts on getting caught up from all the COVID backlog. I know that was a tall order, and you guys really worked hard to deliver justice as quickly as you could, given the circumstances. So I hope that you feel very, proud about that. That accomplishment. It was no small task. So thank you for being here. And we know how to get a hold of you and who to reach to really, Ms. Lehman, we have a little bit of connection here. So we're always happy to work through her or through you. So thank you for being here. We appreciate it.
Thank you very much.
Take care. Next up, the public defenders are here. And while you're coming forward, I'd like to take the opportunity. We have one of our house staff that was home with a sick child when we had our first meeting, so I wanted to give Ms. Davis an opportunity to introduce herself and tell a little bit about what she covers for this committee. Ms. Davis?
Hi, Chair and members, Mary Davis from the House Research Department. I work on civil law issues, torts, family law, civil rights, property law, real estate, things like that. And I also staff the Housing Committee and the Legacy Committee.
Welcome to the committee, gentlemen.
Morning.
We are glad to have you here. And if you would like to introduce yourselves and proceed with your testimony and your presentation, that would be perfect.
I'm Bill Ward, I'm the State Public Defender, and this is Kevin Kyer, who's putting the PowerPoint together.
Okay. We can get rid of you. Let's see. Why aren't you doing what you're supposed to do? Chair, we're having a little issue here. I'm not quite sure why.
Do we have a page or someone that can help out with that?
Yeah.
Okay. Just hit, just enable this add-in for the session only, and that should be
Yeah,
fine.
but I can't get that one on here. It doesn't show up on there.
Yeah, if you don't mind. Kevin, I have her hook up your her computer.
Is that- oh, all right. Actually, here, now that we're out, now it should go, actually. It should go on here, I think. Okay. Excuse me. Madam Chair and members, for the record, my name is Kevin Kyer. I'm the Chief Administrator for the Board of Public Defense. First of all, thank you for the opportunity to come before the committee and talk a little bit about who we are and what we do, and also talk a little bit as going forward about the budget and the needs of public defense. So, okay, we're still having a little issue. So, Madam Chair, our federal and state constitutions provide that anyone charged with an offense punishable by loss of liberty is entitled to representation by a lawyer. Justice Black, in his decision in the Gideon case, stated that we place great emphasis on procedural and substantive safeguards, and yet this noble idea cannot be realized if a poor man charged with crime has to face his accusers without a lawyer to assist him. That's the job in Minnesota of the Board of Public Defense. The board is an independent board within the Judicial Branch. We have 5 lawyers appointed by the Supreme Court. We have 4 non-attorneys appointed by the governor. The board's responsibilities are to appoint the state public defender, allocate the funding from the legislature, appoint our chief public defenders and our chief appellate defender, and set standards and policies for the operation of the office. We have 9 judicial district public defender offices. We have a combined administrative office for our 7th and 8th judicial districts. The appellate office, we have 20 satellite offices around the state and 155 part-time defenders. Our part-time defenders are local private attorneys who work for us part-time, but also have a private practice. And they really are the backbone of public defense in greater Minnesota. They also handle a number of conflict cases. So it's a very cost-effective way of doing business rather than having to go out and contract with lawyers to do that work when there are those conflict cases. We have roughly approximately 1,000 total staff. We have 600 and a little over 600 of those are assistant public defenders, both on our trial level and on the appellate level. And as I mentioned, we have about 25% of those part-time, our public defenders are part-time. The annual budget for the board for this year is roughly $164 million, a little over that, broken out by our three programs that you see there. You can see about a little over 90% of the budget is on the district public defense level, 6% in our state public defender or our appellate office, and approximately 3% for our administrative services office. 97% of the budget is direct service to clients. You are looking at about 30% of the administrative staff for the Board of Public Defense. So it is a very lean organization. 90% of the budget is personnel. Not that different, I'm sure, from some of the other organizations, the other agencies that come to you. Another 6% of the budget is what we refer to as mandated costs. Things like rent, things like data lines, mileage, which is contractually obligated. Roughly 2% of the budget is non-mandated, and those are really case-related expenses, things like transcripts on the appellate level, expert witness fees, grand jury transcripts, those kinds of things. We are the largest user of the court system. About 130,000 cases on the trial level every year, roughly 3,600 appellate files that are opened, 3,800 supervised release, or what we used to call parole revocation hearings. We provide nothing but mandated services, and we provide those services in every courthouse in Minnesota. It's important to note, Madam Chair, members, that the caseloads and the workloads are determined by outside factors. We have no control over that caseload, over that workload. On the district defense side, we're constitutionally mandated service in all of those criminal cases that you see on that list. We also provide statutorily mandated service for children over 10 years of age in child protection cases. In the appellate office, again, the criminal appeals, the post-conviction proceedings in district court, and again, as I mentioned, the supervised release proceedings. Under district public defense, there is a legislative appropriation as well for 4 public defense corporations. These are 4 nonprofit corporations that started well before we had a Board of Public Defense and provide service in about 3,300 cases a year that, but for the corporations, would be public defender cases. It's important, as I mentioned, Madam Chair, that we don't control the caseload. We also cannot refuse cases. There are 2 state court decisions that determine that public defenders are unable to refuse cases. We liken it a lot of.
Sorry, Mr. Kerr, can I interrupt you for just one brief moment for the previous slide? The 3,300 cases that are handled by the corporate, is that included in the number that you gave on like the first slide or second slide of how many cases?
Madam Chair, it is not.
Okay, thank you.
We liken it to the highway department, right? If the chair is coming down State Highway 65 to come down to the Capitol, and there are 20 potholes, if the DOT's only got money to fill 10 or 12 of those, she's got to swerve around the others. We don't have that luxury, if you will. If our defender has 20 clients waiting to talk to him or her outside the courthouse or come to the office, we can't say, oh, we're only going to get to 10 of you today, or come back another day. We don't have that luxury. At the same time, our lawyers are held to the same ethical standards as private attorneys, and they should be. These are 3 U.S. Supreme Court decisions in the last several years that have indicated that responsibility still lies with our lawyers. I will tell you that the number of complaints that we get, the professional responsibility complaints, has risen dramatically over the last several years. Again, as people are busy, as people are frustrated by the court system, by the judicial system. As I mentioned, our workloads and our caseloads are challenges, right? And we don't control those. The first one is time. We have a caseload standard that was developed in 1991, which for the first time ever we've actually been able to meet. This slide indicates the amount of time that a lawyer has to handle a case unit within public defense. And when I say a case unit, we break down for comparisons the caseloads by case unit so that we're able to compare across district lines and compare where attorneys handle more than one type of case. A case unit is approximately equal to a misdemeanor. So right now, you have about 4.5 hours to do all of the things that you are looking at around that clock on this slide that the lawyer has. Mr. Shorba talked earlier about the number one issue relative to folks leaving the judicial branch. What we have found in the last several years is not only salary, although thanks to you and to some people around this table, we've been able to address that, is the workload. That's the thing that's frustrating people the most. That's the thing where we get people in and train them and then they leave. Imagine, if you will, that your lawyer you went to said, yeah, you've got this case, but I've only got 4 hours to work on it. And at 4 hours, I'm stopping. That's the equivalent of what our folks are doing right now. As I mentioned, our caseload standard is from 1991. In 2023, the Rand Corporation did a study of 17 different state caseload studies and came up with a national standard that you see on the right-hand side of this chart here. You can see for each of the case types that our caseload standard is significantly higher. In some cases, 2 or 3 times higher what that national standard is. We are working on a new revised standard with some of our chief public defenders, our staff, our board members, to develop a more realistic standard of what a lawyer should handle in a particular year. The reason behind that, there are a number of reasons. Audio and video, dashboard cam. In 2023, we received 280 terabytes of data. In the first 6 months of 2024, we received the same 280 terabytes. That's without Hennepin County being on our system yet. That's the equivalent of 70,000 two-hour movies. Our lawyers all have to look at that. They have to review that. We are working on some solutions where they can see and review 3 or 4 or 5 different angles at one time, or videos at one time. We are working with folks on being able to get the transcriptions for those through AI, but that's a longer-term situation, and that's from the public defenders will tell you that's the number one issue in terms of a time issue right now. And again, we're not here to tell you that it shouldn't happen. We're not telling you that it's a bad thing, but we're here to tell you it comes with a cost. Not only in terms of time, but also the storage costs that we have in order to maintain that. Scientific evidence. We all have seen that, the increase in what's happening with our phones, with our computers, with DNA. Years ago, with a DNA case might have been a sexual assault or a homicide. Now we have touch DNA. We have cold cases that are now brought up. Again, we're not here to say that those shouldn't be, but again, that expansion of scientific evidence is just another situation where people have to take the time Is the evidence legitimate? Was it collected in a legitimate manner? And again, how is that being used and how is it being interpreted? Chemical dependency, mental health. The court's talked a little bit about that. Representative Rarick is smiling. We've had that conversation over the years. You can see some of the numbers here. You've all talked to your local sheriffs. They are dealing with the same issue in their jails that we're dealing with. 45% of the inmates in local jails and prisons having substance abuse issues and mental health issues. Inmates suffering from mental illness. And the one that we don't talk a lot about, but we're finding more and more, is folks with traumatic brain injuries that then get caught up in our criminal justice system. Again, it takes time for our public defenders to deal with, for our support staff to deal with folks, to get them the assistance they need to frankly just deal with them in a courtroom situation. Language and cultural barriers. Again, Mr. Shorba indicated the increased costs there. Again, we have a changing demographic. And again, it's not only the idea of finding interpreters, but finding qualified interpreters. And also folks that actually speak the dialect, because there are a number of instances where the dialect, the words are different, the vocabulary is different, even within the same language. So, Madam Chair, that's the presentation and the overview. I don't know if you want us to go through the budget request, we certainly can do that. If you want us to come back at another time to do that.
I thought that you were going to do the budget request today, too. Do you have handouts? Yes. Oh, perfect, perfect. Will the page hand those out, please? Thank you. Representative Engen, do you have before we move on to the budget, do you have a question?
Thank you, Madam Chair. Yes, I have 2 questions here. So thank you for the overview. Want to start by taking a look at these public defense corporations. Just off of a quick Google search here, the Minneapolis Legal Rights Center, took a screenshot of it, 1 second, bear with me. They're talking about working with community members to navigate through this inequitable system while also working to dismantle it. That's on their website. With the St. Paul Neighborhood Justice Center, I see that the chair of their board is employed by the Hennepin County Public Defender's Office, and they expressly state that they will take more cases if they're from Hennepin County. Can you talk to me about how you guys determine which corporations you guys work with and deem eligible?
Mr. Kerr.
Madam Chair and Representative Engen, the 4 corporations that are outlined here have been, over the years, statutorily identified, or in some cases, they have not been. So years ago, they were outlined in the specific appropriations to those corporations. In the statute, there is a process for corporations to apply for funding from the board for their operations. So theoretically, some other criminal defense corporation could apply.
Representative Rarick. Not you. I'm sorry, Representative Engen.
Thank you, Madam Chair. Yeah, that's troubling, and frankly, it's dumbfounding to me that we're using tax dollars to funnel it to corporations that are expressly stating their intent of dismantling our system. I think that we should definitely take a look at some of the rules and eligibility, some of the steps that would ensure that these types of corporations are not receiving state tax dollars. Thank you for the information.
Very good catch, Representative Engen. Representative Rarick.
Thank you, Madam Chair. So I was kind of listening to the presentation. I'm just wondering, where are we landing now with the number of cases that end in a plea agreement as opposed to a jury trial?
Madam Chair, Representative Rarick, it's about the same as it's always been. I mean, nationally, I think the level is probably, we plead probably 98 to 99% of all the cases. Our state's a little bit different because we are what you consider a complaint filing state. So If the captain here wanted to file a complaint against me as a felony, he could do that by going through the county attorney's office. In other states, they're called preliminary hearing states or grand jury states. It can't just be done that way. And the reason I say this is a difference is because through investigation, through other means, through pretrial filings, we plead probably less than 96% of our clients. But we're still at the trial level, probably 1.5 to 2% across the board with jury trials and bench trials. That's been the same since I've been a lawyer, frankly.
Representative Bragg.
Thank you, Madam Chair. Yeah, that's been about the same since the last time I was on this committee. I'd just like to keep tabs of that because it certainly is informative of how we make our decisions here. On one of your slides, I think it was slide 17, you have a bullet point here talking about immigration issues, and that certainly is a hot topic as of the last couple of days. Do you keep statistics on how many immigration type issues that you're dealing with through the public defenders?
Madam Chair,
ahead.
Representative Merrick, we do. For those of you who don't know, I mean, the numbers of folks who are charged with crimes who are not legal citizens here, those numbers have gone up quite a bit over the past decade or so. We used to contract with the Immigrant Law Center to help us. We have a constitutional mandate to determine whether these folks can be deported based upon the charge. The nuances are not my area of expertise, and I've been a lawyer for 38 years. It's a specialty for immigration lawyers. And although we were using the Immigrant Law Center for some time, the numbers have gotten up so high that we ended up bringing on board one lawyer who handles immigration cases. Now, the numbers, I can give you the numbers. I'll follow up with the exact numbers because we get those on a weekly basis, and she's housed in our appellate office. The reasons behind it, I couldn't tell you, right? It could be a crime of dishonesty, it could be a crime of falsehood. The federal level changes as to what is deportable or not, and I suspect over the coming 4 years, a lot more will be deportable based upon the law that was enacted in the House, or the bill enacted in the House, that any low-level felony can be deported to. So that means our numbers are going to go even higher as far as people facing deportation issues, and of course, the amount of people who will be languishing in jail waiting for ICE to pick them up is going to go up as well.
Representative Bragg.
Thank you. Thank you, Madam Chair. So I appreciate that, and I look forward to the numbers because I like to live in the lane of truth, and there's all kinds of accusations and, assumptions, and so I would really like to see those numbers as far as the increase and even the severity. I don't know if you've got it also tabulated by severity of charges. That would be fantastic. I just want to know what the truth is. We can't make any policy decisions until we know where we lie with the truth.
Madam Chair.
Mr. Ward.
Representative Merrick, I don't know if we have the severity of charges, right? Also, what happens is if I have a case out in Polk County and a person tells me that they're not, we have a screening process. Are you a citizen? No. And then will go down to the bottom of the box and forward that to our immigration lawyer. The severity of the offense, we don't necessarily keep tabs on that. We have to pull the name of the person that we referred and then compare that database. I don't know if we have that within the next, offhand, to be honest with you.
Representative Bragg, I like the angle you're taking here. Go ahead.
Thank you, Madam Chair. I appreciate you letting us know what you have and what you don't have, because that's equally important to know. I don't want to ask you something that would take 100 hours of your time or something crazy like that to tabulate. That's why I asked if that was something that was readily available. But we'll take the data that you have, because all of that, the real absolute data is what we need to know so that we can make policy decisions moving forward. And so I appreciate that. I appreciate that, that it's literally a part of your screening process. And I'm not making distinctions whether someone is here legally or illegally. I just want to know, are they a citizen or are they not? I mean, that's a whole other level that I doubt that you even go down. I mean, did their visa expire? Now they're not here legally. I don't care. Are they a citizen? Are they not? What kind of information do you have? So again, want to live in the lane of truth. I appreciate that.
Mr. Ward.
Madam Chair, I just follow up. I couldn't tell you whether they really are here legally or not. What I can tell you is when we ask the question, and again, they're not always honest because they think that we work for the government and we're going to give up some information about them. We ask the question, if they let us know that they are not U.S. citizens or they don't have the appropriate documentation, that's how we follow up with our immigration lawyer, because we have an ethical responsibility based upon the U.S. Supreme Court of Padilla to advise our client as to what could happen based upon the resolution of that case. That's the data that we have.
Thank you. Good conversation. Representative Hudson.
Thank you, Madam Chair. I very much appreciate the breakdown of what goes into the caseload, and just highlighting the impact that it has upon defendants. 4.5 hours. Not a lot you can get done in 4.5 hours. So my question is, at what point, and has there been any case law or precedent addressing this, like at what point does it become a deprivation of constitutional rights, like the inability to effectively engage in the work necessary to defend somebody? Has there been any cases in other states where something like that has been adjudicated?
Which one of you would like to take that question?
Madam Chair.
Mr. Ward.
Vice Chair Hudson, that's an outstanding question. I would say that 4 hours is a deprivation of rights. Ultimately, we work within the budget that we have, understanding the case law of Minnesota as to what we can and cannot do. There have been jurisdictions throughout the United States that have addressed this directly, and some have put in mandates as far as capping cases, say in Washington, and they're looking at that in Oregon. I'll be the first to tell you that there's no doubt that things are falling through the cracks, and I'm not happy to say that. I'm embarrassed to say that, but with the amount of workload that people have, they are missing things. They're not looking at all the videotapes. It's impossible to analyze things to the nth degree when you have the challenges and the workloads that we have. I know the ACLU has filed suit in Oregon. They've now filed suit in Idaho. I believe they're contemplating suit in, Wyoming as well, based upon the lack of public defenders in those states. I haven't heard any rumblings about that here because, frankly, we're one of the best funded agencies, although we're underfunded, in the nation. We have one of the best public defender delivery systems in the nation. But our people are traumatized by the work, and that's why they were leaving. They're sticking around now for a while because there's been some stopgap, some relief, and we'll see what as we go forward. I mean, we've got to reimagine filing charges the way we do. We've got to reimagine using the system, not using the court system, but using pre-charge, pre-filing decisions, and not having as many people in the court system in the first place.
Representative Hudson? For the committee's benefit and for the public's benefit, could you tell us the guidelines that you use for determining if someone is eligible for your services financially?
Madam Chair and members, it's not our guideline, it's the courts. The courts determine eligibility. I'm responsible by statute for creating an application that is both on our website and on the court's website as well, so it's easily accessible. The court, once it's filled out, it's submitted to court administration, and the court makes that determination as to whether people are eligible. The language in the statute is a little bit nuanced and vague. I mean, it still says if people are unable to hire counsel after speaking to lawyers in the county about what the charge and cost would be, then the court could appoint them a public defender. I know that people complain about this a lot. I believe the courts do a very good job at screening. They do. Most people are on the bubble, and the majority of people are below federal guidelines. The most important part of that process, and by statute, is if a person gets means-tested income, they are automatically eligible. And all juveniles are automatically eligible, no matter how rich their parents are. And the vast majority of our cases are going to be means-tested income. And the other part of it is for the court to make that analysis as to whether they can afford it. Obviously, a misdemeanor disorderly conduct is different than being charged with a murder case. And so the court makes a determination looking at their assets and liabilities if this is something that they can afford, knowing that no one can afford a lawyer.
Thank you for that answer. All right, Mr. Ward, would you like to proceed with the budget, or is Mr. Kerr doing that? All right.
Madam Chair and members, you all have the handout, or hopefully you do the one-page handout. So the budget request is really two pieces. The first piece is meeting the staffing challenges. We talked about that a little bit earlier, is our caseloads are 2.5 to 3 times what that new national standard says it should be. We are working, as I said, to develop a new standard. I don't think it's going to be as low as what the RAND Corporation is talking about, again, for some of the reasons that Mr. Ward talked about what we do and how we do it. But the request would be to start moving in that direction, so reducing our caseloads by 15% over the next 2-year period. So that's the 14.3 million and the 24.6 million that you see on that sheet. The second piece is the personnel costs. Thanks to this committee, Madam Chair, and your efforts, we were able to achieve parity with the county attorneys for the first time ever. 30-some years that I've been doing this, and we were able to do that. The money that you see there, the funding that you see there, the 11.9 and the 24.3 is for us to continue to be able to have that parity. I know you all have been talking with your county boards about their property tax situation, and one of the reasons that they've talked about the increase in property taxes is their salary settlements with their unions or with their non-union staff in order to keep their personnel. We can't slide back. Again, this is the first time in 30 years we've been able to come to you and say this. We just can't slide back. It is the one thing that we have been able to do to keep people. Again, we reduced our resignation rate, not our attrition rate, but just our resignation rate coming out of COVID was about 15%. So our lawyer turnover was 15% just in resignations. We've been able to cut that down to about 5 or 6%. Again, we're seeing an uptick again because of the workload situation. But we've been able to retain folks, and particularly retain folks that have experience, which is just crucial. We've been able to attract more applicants. We've increased our applications by about 1/3, but they are still well below what they were pre-COVID. And in greater Minnesota, we're still having a real difficult time finding lawyers, finding any staff, but in particular the lawyers. So that's the second piece of it. So, Madam Chair, it's a very simple request. It would add, I believe it's 88 new lawyers around the state, and then the associated support staff that go with those folks. And then, as I said, maintaining that salary parity, which is just critical for us to be able to compete.
Thank you, Mr. Kyer. And just just because we've got numbers here, we don't have a percentage. Isn't it like a 16 or 17% increase that you're asking for in this budget request?
Madam Chair, I believe it's 13%.
13, okay.
Yeah.
Okay. We have member questions. Representative Engen.
Thank you, Madam Chair, and thank you for the breakdown. You guys do awesome work, and you're a lean, mean crew, so I appreciate what you guys do. I want to know what the Public Defense Corporation's increase is from the last budget.
Mr. Kyer.
Madam Chair and Representative Engen, it is that same percentage, that 13.
13%?
Yeah.
After looking at that, I have severe reservations about that. I think that everything else, excited to talk about it with you guys, but that particular increase, after seeing what it is that some of the contracted corporations are doing, that's where I think I would have some reservations, just to let you know.
Representative Rarick.
Thank you, Madam Chair. So I'm wondering, you talked about the personnel cost, which unions are housed within and who negotiates with, for those contracts?
Mr. Kyer.
Madam Chair and Representative Rarick, we have 2 bargaining units, both represented by the Teamsters. One represents the attorneys, and the other unit represents the support staff. And then we have a number of folks that are not represented, our chiefs, Mr. Ward and myself, and we do negotiate those contracts.
Representative Rarick.
Thank you, that's all I have, thank you.
Any other member questions? All right. Well, thank you so much, gentlemen, for being here and for answering our questions. We will be meeting again on Thursday, committee, and with that, we are adjourned.